So once again, welcome, and I hope you're all keeping well to our distinguished panelists as well as our attendees. We look forward to a good session. My name is Joseph Mungai, a graduate intern here at Kabarak University, Center for Multiple Systems of Justice. Before we get into the webinar, I would let the head of department, Mr. Fred Gordon Ogola, who has attended this webinar as well as part of the host, to say a word before we begin.
Sorry, I didn't hear what you said.
Welcome, Sergi. I was inviting you to say a word before we begin, or just to set us off as we begin the webinar.
Thank you so much, Joseph. Mine today is a very simple task. As the head of the center, it's only to welcome the panelists and welcome the audience to this webinar. It's going to be the first of many series that are supposed to come in the future. So I wouldn't have much to say. Feel welcome, relax, and enjoy the expertise from our panelists. Thank you.
Okay, thank you so much for that. As you can see on the screen, maybe at this point, I would maybe now invite our panelists to turn their cameras on so that our audience can be able to see you. And we do appreciate you for joining. As I had introduced my name earlier, I'm Joseph Mungai, a graduate intern here at Kabarak University at the Center for Multiple Systems of Justice. And I warmly invite everyone to this discussion that revolves around arbitration, the question of legitimacy, ethics, as well as power play in arbitration. As we begin, I would like to bring to your attention that this is part of a webinar series that will follow in the coming month on a theme arbitration on trial, legitimacy, power, and ethics in Kenya practice. And hence, as part of it, we have conceived or conceptualized the first part of it that will be dealing with the question of arbitrator selection, referral networks, and concentration of opportunities in Kenya arbitration practice. Then what we'll be interrogating in today's session is a question of whether it's community or is it more of gatekeeping, and that we'll get for sure from our panelists. Just for the purpose of context, the Center for Multiple Systems of Justice is the one that is convening this webinar, which is a dedicated department here at Kabarak University with a core mandate of enhancing the teaching and as well advancing of alternative justice systems, as well as alternative dispute resolution mechanisms. And how we do this through moot court competition, through webinar like this one, through policy engagement, and as well as research. And today this webinar forms part of our mandate, and hence the need to interrogate this topic further. As all of you, or most of you, would agree with me, there are not many topics in arbitration that draw so much controversy as the concern of legitimacy and ethics in arbitration. Hence the need to evaluate this topic in this session today. To do so, we shall be joined by 3 panelists, and one of the panelists is yet to join. I will introduce her once she joins. First, we are joined by Senior Counsel John Ohaga. He is a chartered arbitrator and as well a fellow of the Chartered Institute of Arbitrators. He has expertise in arbitration, mediation, and as well as commercial litigation, spanning over 30 years. And it's for this reason that he is fit to be part of this panel. As most of you as well could note that he was as well appointed as a member of the Court of Arbitration for Sport. And I don't think Mr. John Ohaga needs further introduction beyond that. Secondly, we'll have Mr. Nyanje, who has joined us today. To introduce to you who Mr. Nyanje is, Mr. Nyanje is a Kenyan lawyer with a broad expertise in international law and growing footprint in transnational litigation and global legal scholarship. He holds a dual LLM in international law, LLM in international law, as well as international dispute settlement from University of Geneva and Graduate Institute of International Development Studies in Geneva. He recently completed his PhD at Leibniz University, Hannover. You let me know if I pronounced that right. I hope I did. He has acted in international commercial arbitration, investment arbitration, public international law, and sports arbitration matters before institutions such as the ICC, LCIA, SCIA, SIAC, PCA, ICSID, and Mr. Nyanje will be part of our panelists today, and we look forward to hearing your insights and what you bring to this whole discussion today. Just as part of gatekeeping, I would like and allow me briefly to introduce to you how this session shall flow. During the first hour of this session, we undertake a discussion between the panelists that is dedicated specifically towards evaluating the topic that we have laid out today. After which, we shall open the session for Q&A, or what will be an open Q&A, where our attendees will have an opportunity to interact and ask questions directly to our panelists, who for sure will endeavor to answer the question adequately, so long as time will permit. And therefore, during the session and throughout the discussion, I would encourage anyone during the first hour, if you have any question, you can type them in the chat box. And during the Q&A, we'll endeavor to make sure that we get to the specific concern that you would have raised. And without further ado, allow me to introduce to you our panelists and delve deep now to the subject matter in question. And perhaps I will begin with Senior Counsel John Ohaga. And as you come in, I would...
Joseph, before you proceed, Ms. Waihenya is asking to be admitted.
Okay. Maybe she has joined with the wrong... I'll ask Baraka. Baraka, because you're here, kindly help me with admitting Ms. Jacqueline.
Or send her a link. I think she may have misplaced her link.
Okay, so you give me a minute, and as I admit her, I would let you come in. And as you come in, Senior Counsel, you have been in practice in arbitration and mediation for, I would say, a period of close to 30 years. And the question of arbitration selection is a highly debated topic. What do you think are the main concerns as to why arbitrator selection is often contested? And from your practice, what are these key things that you think the arbitration practice itself fail at times to recognize, and as a result, these concerns often recur time to time?
Yeah, that's an interesting question. And I suppose the entire topic, as you aptly put it, is around legitimacy. And so the issue is whether choice of arbitrators erodes or enhances legitimacy. But I think what needs to be understood first and foremost, and I'm sure that John will agree with me on this, is arbitration is relational in the sense that the users of arbitration, they depend on the confidence of the person or the panel to whom they entrust the resolution of that dispute. And so because you understand that arbitration, first and foremost, is built on a pillar of party autonomy. So parties have choice as to who they want to select in the first instance. In fact, before the institution comes in or before the court intervenes to appoint an arbitrator, the parties would normally have first choice as to selection of the arbitrator. And that means, therefore, that the parties would be looking to identify somebody or a panel that they think that they can trust, somebody who has expertise. And you have to understand that once you commence an arbitration, you look to the end of the arbitration. If you are the claimant, in the end, what you want is an enforceable award. And so therefore, competence becomes key. Because you will be paying this arbitrator or this tribunal to give you an enforceable award. And so you do not want to be investing, because that's what it is. You don't want to be investing your money potentially in a venture which may result in an outcome that cannot be enforced. And so therefore, the credentials of the individual or the panel to whom you entrust this is of utmost importance. And so I started off by saying that it is relational, which means therefore that things like name recognition come into play. Things like recommendation come into play. Things like if it is an individual that you have no knowledge of, things like a scrutiny of their resume comes into play. And so there are all these factors which you must take into account because you have to, there has to be a significant amount of trust that you're putting into this process. Unlike your municipal courts where you really have no choice. When you file your lawsuit, the first time you appear before a judge whom you haven't previously known would be selected to handle your matter. It might be a new judge, for all you know, it might be an experienced judge. And what you rely on, therefore, is hopefully the competence of the judge in the subject matter and the fact that you have, honestly, a potential appellate opportunity. Now, that appellate opportunity is very narrow in arbitration. So it makes it even more important that you have competence and that you have a criteria that means that your selection is one that will get you to where you want to be, especially where you're the claimant. So I'll just stop there because I know that my colleagues might have much more to speak to this issue.
Thank you so much, Senior Counsel, on that point. And in that vein, I would as well want to bring in Mr. John Nyanje on the subject of arbitration and the process of selection being so relational. And the question becomes, to what extent is the legitimacy of arbitration tied to the individual who is given the mandate, or rather has been enabled by the parties to arrive at a decision on their behalf? To what extent is such legitimacy tied to an arbitrator?
So thank you very much, Joseph. And first of all, let me begin by congratulating Senior Counsel John Ohaga on being appointed to the past court. I think that's a very important body. I mean, the last 2 years now, we've seen 2 Kenyans get onto the body. So I think that's a very, very important point. And of course, also, Madam Jacqueline, I'm very happy. I think last time we discussed, I really insisted that you become one of the members of the PCA Kenyan group, and I'm happy that you've become one of the members, and now we have a woman on the list. So I'm very proud and happy to see that. Congratulations. Let me say appointments, and this is a very interesting topic because I've spent this morning here at the Johannesburg Arbitration Week with various institutions just discussing the same things. if you look at the data, the data tells a very different story. 95% of appointments are party appointments. The institutional appointments are less than 10% most of the time of who become tribunal members. And when you look at the credibility vis-a-vis, even things like diversity, gender, and all other aspects, when the institution is making the choice, you tend to see some deliberate effort towards covering that ground. When the parties are doing it, there's still some shaky ground there, right? And the reason is because parties come to the table with an idea that they must win. So, and I think in commercial arbitration, the decision of how you end up in an arbitrator many of the times is quite different compared to, for example, investment arbitration. It seems a lot of more thought goes there, but also because there's a lot of work written publicly on views about investment arbitration. Now, that choice is very important because it ends up, and what John has said, it ends up at a place where people tend to think whether, is the award competent? Is the award well written? And I mean, these days, of course, almost every arbitration institution is trying to read the award before it's released and make corrections, albeit minor most of the time. But that choice of that person is very important. Yeah. So, but you tend to see a certain aspect, and I think, from counsel work here, I think many of the times the parties tend to drive who they want in an arbitration. So, right, you have a dispute, you've really thought about it, you have proposed names, and the client will just tell you, I don't want that guy. I was told by my friend there's this good guy, that is the guy I want, right? And many of the times you are unable to overrule those opportunities. And sometimes you get an institution appointing for you an arbitrator, and at the same time, the party just out of their own evolutions of thinking, they say, I don't want that, yeah? 8 years ago, I was a very young lawyer. I had a PC arbitration where John was appointed, and the client told me, I don't want John. And so I had to challenge John's appointment. And it's not like he doesn't want John because he doesn't. I knew John, but he's a South Sudanese guy who doesn't know anything. And he says, no, I don't want any Kenyan. Kenyans have a collusion with the other parties. They will mess up my arbitration, right? And it's a perspective, a perception issue. So I think that choice is very important, but that choice, I think lawyers must need to spend a lot of time guiding their clients that we are making the right choices and the right decisions. I think, what many people do, at least try and bring your parties into the understanding of how the system works and what is important for them. Because what you need is impartiality. It is not a system which will favor you. The most important act is, will the tribunal act as impartial as possible? And remember, number two, arbitration, as John says, requires a bit of knowledge and experience, because you also don't want somebody who might be impartial, but is making so many mistakes along the road. You end up with very funny procedural orders that overrule some of the issues that you're dealing with, and then at the end of it all, you don't get a good award. So that is something I think we should encourage with the parties. I'm not really worried about the institutions. I think they make the right choices, but the parties is something we really need to work on.
Okay, thank you so much for that insight. That indeed parties do play a greater role in establishing or rather selecting who the arbitrator will be, and then the concern there becomes to the extent to which maybe the parties might want the arbitrator to be inclined to favor them, which will be a different concern as we'll discuss at some point in this webinar. And seeing Miss Jacqueline is here with us, allow me to introduce her to our audience. To our audience, Ms. Jacqueline Waihenya is the chairperson of the Institute of Certified Secretaries and is the Emerita chairperson of the Chartered Institute of Arbitrators, Kenya. She's an advocate of the High Court and governance expert. She brings a strong track record in shaping legal practice and advancing ADR. Thank you so much, Ms. Jacqueline, for joining us today. We are privileged to have you. And as you come in and to make your introductory remark, and having worked at an institutional level, the question then becomes, what does the vantage point or perspective from an institutional level say about arbitrator selection?
Yes, thank you so much. This is Joseph Mungai, sorry, I beg your pardon, for that wonderful introduction. And it's great to follow after my senior counsel colleague and also my good colleague from the PC. And thank you for your good wishes, John. I finally made it, and thank you for encouraging me to take that walk. And one of the reasons I really thank you for raising that issue is because you've raised the question of gender. And of course, there are other issues that you've raised that include nationality. And then also, because we are speaking to our younger brothers and sisters, the question of youth does also come into play. And from an institutional perspective, because I've just come from being chair at C.Arb, all the usual considerations that parties, when they're appointing a neutral is an arbitrator mostly, but nowadays we also have construction adjudicators, dispute boards, and also in many cases now also mediators as well. But from the formal appointment pathways, the question of party autonomy still plays in, because the first thing that the institution will check is to see what did the parties agree. So their arbitration agreement, their dispute resolution clause, what did it say? Do they want, sometimes they will say they want an advocate, if it's a domestic, an advocate of 15 years, an engineer, maybe of the same registered engineer, because they try to distinguish between the other engineers. And when they say registered, they might say, we need a civil engineer, we need a structural engineer. So all those are, that is the first question that we have to ask. So party autonomy still plays a direct role, and the institution will always be, we're actually bound by what the parties agree. So we'll be looking at ensuring that we comply with what the parties have put down on pen and paper before the dispute crystallized. Sometimes the dispute comes through court, so the court order will also be of consideration, so that we can make sure that we also comply, because our courts are empowered to do that under the Civil Procedure Act and rules that we have. So we are having all these requests for appointment coming from different directions, coming from different quarters, coming from different parties in different industries of complexity, and also a different amount of quantum that is anticipated by the party who would want to be or is more likely than not will end up being the claimant. So one of the things that we also check, because by the time the parties have come to us, usually I think it's almost standard in all dispute resolution clauses, there are at least two stages. There's the amicable settlement we will discuss. We will do good faith is always a part of that clause. So we also want to see a demonstration that they attempted to negotiate. They attempted as the parties to appoint an arbitrator. And for those arbitrators who are nominated at that stage and the parties are not able to agree, like the one or the case that John gave, John Nyanje gave about wanting to appoint senior counsel John Ohaga. If John Ohaga's name appeared and several others, usually they have a list of 3. Usually by the time it comes to the institution, we presume that the parties will not accept that an appointment of any of those, notwithstanding how competent those proposed names have. And then of course, we then look at what qualifications is required for the dispute. Different bands of disputes with different technical requirements, and especially when the quantum is high, we tend to say that, look, we have different categories of our neutrals. They may be fellows, they may be chartered arbitrators, and then the other level then comes to the member, C.Arb, or the associate. Usually we don't appoint associates. We want to give them an opportunity to go on and continue their learning journey. when they do hit the membership level, what we tend to do in the institute at C.Arb is to match them with a more senior colleague, and we put them in mentorship so that they can work with a senior arbitrator, so they can learn the ropes by observation. And then, at least when I took the role, we didn't have many, even up to now, we don't have many female arbitrators. So I'll start with the women arbitrators, the women in arbitration. So there was a concerted attempt to ensure that where the women arbitrators are competent and qualified, then we would place them, we would appoint them for the role. Sometimes, because some of our members are QSs, quantity surveyors, engineers, and those in the financial sector, and finance is quite broad. It's banking, it's insurance. If there's a claim, then what we do is to look to ensure that we put them in, as the appropriate arbitrator. Now, it may seem that we have a small pool who get a disproportionate share of appointments, but then first we have 4 chartered arbitrators who are women only. And from the beginning of when we started C.Arb 40 years ago, we have had a sum total of 40 chartered arbitrators. Some of them, of course, they are of blessed memory. They have left us. So the pool tends to shrink, and the opportunities, we have actually had an increase in the request for appointments. So if the value of the claim is high, then it may seem that we are circulating within an elite. But this elite is, when you described Senior Counsel John Ohaga, you said he needs no introduction, right? Honestly, sometimes it just means that you just see a matter and honestly, this one is a good match for Senior Counsel. And really, the challenge never really arises over the small value claims. It's always the higher value claims. So we have many opportunities to ensure that we are engaging in transparency, because transparency in appointments builds legitimacy, and also diversity in appointments builds the future. That is why we have always, at least from the time I was at the helm, we ensured that our mentees also had an opportunity to learn at the feet of the greats. I think I can stop there. And
Thank you so much for that introductory remark. And as well, I do note that in introductory remark, you covered sufficient ground and very wide in terms of inclusivity, in terms of the ethics, in terms of selection, and for sure, they're part of what we're going to discuss. And allow me to stay on that point that you concluded on, and from what you have said, and when listening to you, I'm trying to contrast 2 ideas here. The first idea being the party autonomy. To what extent should a party be allowed to select an arbitrator vis-a-vis the institutional mandate to ensure that the person being selected is qualified, even if the party do not prefer them? And secondly, in as much as you said that it's a perception and maybe a fact that there seem to be a pool and a small one that people get selected, and probably that could speak to the merit. But the question then becomes, what happens then when this individual who the institution holds within their roster of qualified arbitrators, in any case they exist, what if the parties select an individual and they don't prefer the ones that are not found within your own roster? How do you go about such a conflict? Or is there such a possibility?
yes, many times when we would look at usually it's a list of 3, the first list of 3, invariably we will find members who are already members of C.Arb, and they're already in our roster. We have their CVs, we know who they are or what they do. But then also, invariably, we may find names of arbitrators who first may come from across the border. Secondly, who may be coming to us from, whose names we may know because we have interacted with them. In reality, and I think both Johns will tell us that the community of especially international arbitrators is actually pretty small. We tend to know each other fairly well. And what that therefore means is that even if they're not our members per se, we may have their CVs. But then from an institutional perspective, if the parties have appointed and they did not come to a consensus on any of them, then we believe we have no basis for appointing a person who has been nominated but not accepted. I don't want to use the word rejected, but for us, that party autonomy has already demonstrated itself. They have come through and said, we want you to appoint for us, but because they didn't agree on any of them in the past, we are not going to force any of them on their part. When it comes to party autonomy in arbitration, that is the fundamental requirement. It's a fundamental consideration. Even if you look at the Arbitration Act, here our Arbitration Act, it just starts, unless the parties otherwise agree. That is fundamental. We are not going to depart from that. If they have appointed somebody else outside of the institution, we also have no business being or making any, or even participating in that particular proceedings at all. So the Act already tells us, unless the parties otherwise agree, then this is what we are going to do. And when it talks to nominations, it's pretty straightforward. Now that they have come to you, then you're looking at, number one, their dispute resolution clause. Is this what they agreed upon? Are these the qualities of the arbitrator that they're looking for? Do we have somebody in our roster who fulfills those qualities? If for any reason we're not able to get somebody who is able to fulfill or fit their requirements, then what we'll tell them is like, look, we have seen your dispute resolution clause. We do not have a person with that requirement, but we do have these people, and we'll send them the CVs and then ask them to, first of all, agree amongst themselves, or otherwise come back to us with an amended roster of qualities, if you like. Yeah, I hope I've addressed your question.
Wonderful. And on that point, I would as well want to bring in our senior counsel, John Ohaga. And I would, in a way, tweak the concern and try contrast this as to when there exist institutional arbitration rules and institutional arbitration proceeding vis-a-vis an ad hoc tribunals that in themselves might not be affiliated to an institution, or in any case where we might have sole arbitrators and private arbitration, is a concern of arbitration selection in this regard could inform the reason as to why parties at times will choose to go for an ad hoc tribunal or an ad hoc arbitration rather than going to an institutional arbitration governed by a certain or specific body. What are your thoughts on that, senior counsel?
Well, that's an interesting question. I think what you have to understand is that whether you go for an ad hoc, whether the dispute resolution provision can be defined as ad hoc, or it includes an institutional framework, the parties have first choice. So there is no automatic provision requiring an institution to appoint an arbitrator. And John just gave you the statistics. He said to you that 90% of appointments are party appointments. So really, ad hoc just means that there is no fallback to an institution. There is no institution that would otherwise appoint the arbitrators. But at the bottom of it is that the parties necessarily must have exercised that autonomy to appoint whom they want. Now, you then have to recognize the difference between ad hoc and institutional, because when you go into an institutional framework, then you have the safeguards of process, because the institution oversees the way in which the arbitration is run. And depending on the institution as well, there would be a structure as to what fees are paid, whether the fees are charged at an hourly rate or whether they are ad valorem. That depends on the institutional rules. When you go into an ad hoc structure, really, you depend on the arbitrator to determine what his fees will be, and of course that depends on his designation. And then you depend on the arbitrator to manage the process. Now, I think that ad hoc arbitrations, generally, in my experience, are better able to define elite from those who are on a more mundane track. And that's not just because of their decision making, but case management. Case management is very, very important in arbitration, especially when there is no fallback for the parties, when there is no institution to review an award, when there is no tribunal secretary to prompt the arbitrator, when there is no framework for a procedural order number 1 or terms of reference. You are relying on the arbitrator to be able to design all this. You're relying on the arbitrator to give you confidence that the process is legitimate, that the process will be smooth, that the process will be properly structured, that the forum is one that the arbitrator will design so that, for instance, if the arbitrator is offering you a virtual platform, what is the choice of that virtual platform? If the arbitrator is offering you a physical hearing, what are the choices that the parties are able to make? Does the arbitrator make those options available to you, or are you having to prompt the arbitrator? And I think that, in my experience, defines the pathways that we take, because you don't have the comfort of an institutional arbitration. And so those would be the major differences between those. And you know, it is whether you are in an institutional arbitration or an ad hoc arbitration, I have really found that it actually is a truism that the arbitration cannot rise above the level of the arbitrator. If you have an arbitrator that is incompetent, you're going to have a bad experience with arbitration from start to finish. If you have an arbitrator that is competent, you are going to be able to hopefully enjoy your arbitration, whether it is ad hoc or whether it is institutional, and you're going to be happy to pay his fees. That's what I would say.
I appreciate Senior Counsel. And just to put briefly what you said is indeed that arbitration is fully tied to the arbitrator who oversees it, and as a result, it cannot go beyond what they can provide. And indeed, if they are good, then the arbitration experience will be good. And if they're not good or merited, then you don't expect anything good from it. And on the same vein, and now bringing in Mr. John Nyanje, allow me to ask this question. When parties go to arbitration and they have now the ability to exercise party autonomy, they get in some way to say, I would want that individual to be the one overseeing our disputes. Do you think there's some level of in-depthness on the side of the arbitrator that indeed I have to give a favor to that individual? And I know that revolves around the topic of being impartial, but they are all humans and they do understand that maybe for the sake of another appointment, and maybe these are client or someone who can appoint me in the future, I might have to give a favor back. So what do you have to say about
that? So thank you very much. I think let me speak about my own experience, because I don't want to talk about people. But I select arbitrators based on whether I think, first, they're very good at what they do, and secondly, will they understand my argument? That's my thinking. And let me tell you, for example, let me go back to what just we were discussing a bit. I look at the list from the institution, the last, every time I have a dispute. Because when I have a dispute, my first thinking is, okay, who fits in this area of law? what is their name, what have they done before, what have they decided before. And then I go to the list of the institution last. And that has always been my thinking. I don't take the list first, because then at least even if I cannot fall on what I want, I will have something that I will be comparing with when I go to the list and check the list. And so in appointing people thinking there is return favors, first of all, I think that's a very bad way to run your case. Like we say in Kenya, watu sio wajinga hivyo, everyone knows everyone, right? So for example, I have a dispute today at the African Arbitration Foundation for South Africa, AFSA. The arbitrator I thought was most competent and qualified is a well-renowned Kenyan lady. I don't want to mention her name for obvious purposes. And I proposed the name, and the name has been challenged, not because we have any, very close personal relationship, but at some point we used to work for one law firm in Geneva together, right? And the parties feel that, if you have a certain working relationship with somebody, you shouldn't be able to nominate them. And I agree, it's a very fair argument, right? So I think in terms of making our decisions, I don't think any competent lawyers do it because they believe somebody will give you a favor back or will do something. What if you are somebody who does never want to be appointed as an arbitrator, for example? There's some people who are just not interested in it, right? So what favors will you be returning to each other? And I think that's the wrong type of output that actually leads to a lot of distrust in arbitration, right? So I think we need to grow the pool wider. The relationships need to be, well managed, especially when you have a small working group. It's something you really need to think about, those type of relationships and how you work on them. But unfortunately, in arbitration, it becomes very, very hard. So for example, there's an award that is written by the renowned Swiss arbitrator Gabriel Kaufmann-Kohler against Argentina, and she says in her challenge that it's, arbitrators are not people who live in heaven and show up when a hearing comes up. They have personal relationships, and she had been challenged. I think this is in Vivendi versus Argentina because of her relationship with Credit Suisse as a bank where she sits as a board. And her argument was, I live on earth. I have certain, interpersonal connection relationships, but it shouldn't be obvious that there is, some certain favors that are being given to some people. But I also think as a lawyer, if you make such a selection, then you're really making a bad choice. Your choice should be on the competence and on the outcome of what you're going to get, not returning of favors. But I'm not saying that there are no rumors that people do that in exchange of favors and whatever. I would just find it very absurd.
That input, and indeed, as you put it, arbitrators are just human as any other individual. And then that turns us to an important part of this discussion on the question of referral networks. As you have said, the lady, as you've not disclosed a name, you have some interaction in be it professional, academic, and that in some way led to you making a recommendation, if I may put it as such. And as a result, people tend to think that it might not be merited. And on that point, then I would ask this question, the question of symbolic capital in the event that this individual, they are competent enough, and as a result, that's why I would give a recommendation. How do we contrast these two arguments that on one end, to avoid being inclined on having some referral networks to the extent that they diminish the purpose of the whole process, vis-a-vis the capability of that individual, and thus hence why they are often or they will be preferred. How should we go about that? Or what in itself should be the solution to such an idea? And then as a result, we get a smaller pool because then we don't want to get out of the way because, again, maybe it's preference.
To be very fair, I have no answer, right? Yeah, it's something I struggle with because sometimes I just like some people. I think this is the person that I want, right? And this person will give me a fair award. But you have interpersonal relations. Maybe you've interacted with the person. you've worked together in a matter, you've done, and your thinking is not even that I will get, a certain favor from them, or you just think this is the most competent person. And this is a conundrum that is very hard to solve. Let me contrast it to you. Today, this week, there is a case that is going on before the Johannesburg Constitutional Court, where there is a law that requires that all top law firms that want to get work from the government must comply with the BEE requirements. And that means raising at least 25% of the partnership to be black, right? Now, to you to get to partnership level, John will tell you it's a work of experience and time. You just don't go picking people and say you are a partner, you are this. It takes time, and that's the argument they're presenting before the court, that some of these requirements you're forcing us to make are hard to make. Sometimes the pool is just small. The pool is within a very small range, and that is the pool you have, right? So I think we should be more concerned about the impartiality, the awards that we're getting. But of course, you want to see fairness and justice outside there. And I hope that fairness and justice is seen in the quality of the awards we want. So for example, the case I was given of that lady is maybe one of the most competent women in international arbitration today. She speaks 4 or 5 languages. She's extremely good. She's sat on almost every board you would think of international arbitration. And she's an extremely competent, arbitrator. But because of that perception of, no, there is no way I can compromise her. It's not possible, right? But that party, that feeling of the party that is not fairness is actually, to me, much more important than me insisting that that person should be an arbitrator. Because at the end of the day, my award must look like an award that has been given at a very partial level. So sometimes you would willingly let it go. And when you willingly let it go, at times it affects, maybe you don't get the same quality of what you wanted. But all I normally say is that a party appointment place is, it's like a dice. Sometimes you get what you want, sometimes you don't get what you want, and you have to live with the choices. So for me, I'd rather lose the arbitrator that I want, but at least the other parties feel that the process is fair.
Can I just add to that, because I think that it's a very nuanced situation, and I have the benefit of doing both counsel work and sitting as arbitrator, as well as doing policy work. So it's a sort of wide spectrum, and it's always interesting to give examples. I'll give you 2 examples. So in one example, I was a party appointed arbitrator in an international arbitration. The other, my co-arbitrator contacted me, somebody I didn't know, but we have both been appointed by parties in an international arbitration. And it was a lady, and we now he has given me an extraordinary opportunity, but I'm not influencing him because we are both going to be arbitrators. I'm just making him our presiding arbitrator because I figure we'll be able to work together, and we also have a relationship. So behind the scenes, the reality is the parties do not know that interplay, in the selection of presiding arbitrator. The second example I want to give is a very interesting example, because even I had to be amazed. So I was contacted, John mentioned the PCA, I was contacted by the PCA in a matter in which they were trying to select arbitrators. I was traveling and pressed for time, and so therefore I put in my expression of interest late. And so they came back to me and they said, sorry, your expression of interest came in late. We've already selected the 2 other arbitrators. Now, unknown to me, these 2 other arbitrators, who are both international arbitrators, got together and they decided that I should preside. So on the one hand, I'm being asked by the PCA to put my name forward. I'm late, but the other two arbitrators who have been selected, unknown to me, have me in mind. And I'm now the presiding arbitrator in that arbitration. Now, how they came to that decision is a question, is again a relational question. Because we know each other, we've been in forums together, we have spoken together, we have exchanged views on various things, and so therefore, they are comfortable, even though we are all of different nationalities, they're comfortable working with me. Again, the parties have no insight into that. Yeah, and this is the thing about arbitration. There are aspects of it, of choice of arbitrator, which the parties, even though we tout party autonomy, once the parties give up that autonomy, they lose control of the choice of arbitrators, and they have no insight into how those arbitrators are selected. And what they do know is when the tribunal is presented to them, and they then hope that this is a tribunal that will be able to give them an enforceable award, or that will be able, as John says, to understand their arguments. Because, I mean, you want somebody who understands your arguments, who will appreciate your arguments, and who hopefully, I say, will decide in your favor. Not always the case, but that's what you hope.
Thank you so much, Counsel. Thank you, Senior Counsel, for that insight once again. And now, as I bring in Ms. Jacqueline Waihenya, and also building up on the aspect of relational aspect of arbitration, there's often in the host of scholarship or literature in the subject, at times could term it because people know each other in the field, and as a result, they believe each other to be merited, hence a referral, or rather the existence of referral networks. However, at the same time, that these new individuals in this context to be young practitioners who are trying to get into this space and trying to get their appointments. And I do note in your introductory remark, you told us about the bands in which an arbitrator at times follows to get to a certain level. But often as young practitioners at times see this as grand old men. This is not to put anyone on the spotlight, but it's often termed as grand old men who at times keep the opportunity to themselves. And then here's a question of struggle of an individual trying to get to the space, vis-a-vis how each and every individual who wants to go to arbitration wants to build on the aspect of symbolic capital, and as a result, a young practitioner do not bear the same symbolic capital as an accomplished or someone who has been in the field for long. How does such a scenario, and even in your practice and governance, how do you see this scenario of the struggle?
Okay, I think I will start from here by answering you that the struggle is real. And I'm sure Senior Counsel John Ohaga and John Nyanje, they also had to start, everybody starts right at the bottom. So this is not a unique experience for you, Joseph, or for your colleagues. We all at one point were young counsel. At one point, we were young arbitrators just breaking into the space. And for all of us, and we must be really alive to this, we are all Africans. And even when you walk into the room, the social capital is sometimes zero, sometimes even negative. And because there have been established networks in arbitration, especially at the international level, it has taken an incredible level of investment by those who have come before me, and even those who are currently in the space, for us to be able to say, you know, well, it's not the highest number of arbitration references, but it is a significant amount. I think sometimes we bandy around figures like almost 40% of all international commercial arbitrations, and especially also those which are in the investor state. They relate to Africa in one way or the other. And I know Senior Counsel John Ohaga has been at the forefront of speaking about this. And even if you see him today and you say he doesn't require any introduction, he has been doing this for more than 2 decades. even when you look at John Nyanje, he had to go and also study. He had to go and acquire the credentials. And what we're calling social capital is one individual at a time. These are networks we have created by interacting with one individual at a time. And when you hear John Nyanje saying that, I think I have an idea who he wanted to appoint in AFSA, it just means that their paths have crossed severally in engagements. And that is why you see, even for us, because, okay, I really believe in mentorship. And I always think everybody should be given an equal opportunity to have a foot up, I mean, a leg up or a hand up, if you like. So I always look for opportunities to say, let me see who is doing a good job, who is making a name for themselves. And I want to underline making a name for themselves. You cannot believe the number of conferences that both John Nyanje and John Ohaga have attended. Now, it may not be feasible for a young student to go for the international conferences, but it is feasible for them to ask themselves, what is C.Arb doing? What is NCIA doing? How can I plug in? And how do you plug in? And this is the strategy for everybody who wants to get into this space, at least at this point in our developmental curve. First, get in and be a rapporteur. Offer your services for free. I know it sounds like exploitation, but the truth of the matter is, even we offered ourselves for free for the first one. That's because we are not going to be able to identify you if you're not visible. And when you turn up and you see senior counsel and John Nyanje in the same event as you, make a point of just saying hello and telling them I am so and so, this is what I do. And it may not seem like it is significant in the moment, but life is made up of many small, significant, consistent moments over a long period of time. You don't have to wait to meet people in person. Every time, and I know Kabarak has a strong tradition of publication, I always encourage, you are in the intellectual space now, you are in the academy. Let your opinion be known, because for us, what we think, even when we're looking at what competency do you have, we want to say they have written. This is their opinion. They know something about this particular space. So be ready to share your experience. There are no wrong answers in this space. Once you're engaging with your undergraduate, your opinion can speak and should be able to stand on itself for yourself. I may have a contrary opinion, but the beauty of learning and knowledge creation and management is that your opinion, somebody else's opinion, always comes into play when we are trying to resolve a problem. And what you say is yours. It belongs to you. And as you start expressing your opinion, as you grow, you might find, by the way, within 5 years, you may change your opinion and you'll be right about the same subject from a different perspective and come up even with a completely different or nuanced position than you had before. So I want to encourage us all, because whenever I speak, especially to lawyers, I use this term, and we all use it, and sometimes we use it without thinking too much about it. We are learned friends. We are all learned friends. What are we learned about? We are learned about a wide array of subjects. And we appreciate each other because we're contributing new learning, new knowledge, new perspectives and ideas. And all of us will be the better if each learned friend is a learning institution. You're an institution in yourself, just the same way Senior Counsel John Ohaga is an institution in himself, just the same way that John Nyanje is an institution in and of himself. And if each and every one of us plays their part, then we'll stop seeing this cake as though it is finite, because it is not. The more opportunities we create for ourselves, the more opportunities there will be to go around. And what I do, it has an incremental effect in the long run. So social capital is always going to be the way, and I speak from a governance perspective. And also because in the recent year, or actually 2 years, since we got new leadership in the free world, the one thing that we've been able to establish is that uncertainty is the only guarantee that we have. And in an uncertain world, in an uncertain ecosystem, the one thing everybody wants to see is, the first question they'll ask, regardless, is, can I trust? Can I trust the process? Can I trust the institution? Can I trust this arbitrator? Can I trust? And everything rises and falls, we say, with governance, but governance is really a system of guaranteeing trust. So it is up to you. And by the way, I'm also on the, we call it spectrum. I am also looking up and saying, one day I may be, but I will be like Senior Counsel John Ohaga. I will be like John Nyanje. Yes, you heard he's been in the PCA. I joined the PCA last year, almost to the, to the date, the last year, May. And because he and others also recommended me, they proposed that I take this step. They saw that I was ready. Soon I will be saying the same thing to Joseph Mungai and many of the others whom we're seeing behind us. And I've spoken about Africanization since I became chair, because when I came, that was the hot topic. And we wanted to see an increment in African arbitrators. And we kept on being told we can't appoint arbitrators. I'm sure we don't have sufficiently qualified arbitrators. And I said, no, we have to say that, because we were being asked, so what quota do we want? We want the same quota as everybody else. And I was saying, until and unless we have 50% of African arbitrators being present and considered for arbitration appointments, we will not have achieved the diversity, equality, or equity and inclusion dynamics that we require. And there has been a strong push, and there has been an even stronger pushback. So this is our time, and we need to make it count as soon as possible. Thank you so much, Joseph. I can actually go on this subject indefinitely.
Indeed, and I know you're very passionate about the subject. And in my opinion, I find it as a blueprint for any advocate who intends to get into the space. Rather than lamenting that indeed this space, it's impermeable, I think you should make the attempt. And you quite remind me of a saying that out of sight, out of mind, that you need to be seen for you indeed to be recognized. And as a result, young practitioners, you should get yourself into the spaces. And as well, you as well reiterated the question, the concern of compounding. It's more about compounding and not looking for an instant gratification at the moment, but in the long run. On the same point, and to bring a different dimension to the same, and I would bring in Mr. Nyanje on the topic. The concern now here, maybe the question I would ask, I don't know if in your view, you see yourself as within the struggle of trying to get to higher echelons of arbitration, or indeed you would say to some extent you've gotten your way into it, and also backing it with the fact that this opportunity, in as much as that everyone is fighting for them, there are only a very few number of individuals who can really get to the very top. And there's a lot of individuals who who definitely not get to the top. And in preparation of this, I found a piece, I would say, an excerpt of a literature, and allow me to read it out so briefly, and then tell me what you think, and also try to relate it to your experience in the whole field. And it cites, the son of a nobleman could become a bishop of a church simply because of family background and social prominence. Others would shave their heads, take vows of celibacy, devote everything to the church, and yet have no chance to rise to the eminence such as bishop. Their hard work would help maintain the institutional structure that made the position of bishop attractive to the son of a nobleman, but they lacked the social platform to gain that top position. What's your thoughts on this, and how do you think this relates to most of the individuals that you have interacted with in the field?
Yeah, Joseph, so I think that's a very important excerpt, but to me, it teaches me one thing. It teaches me to make deliberate choices of what you want to be, right? I've taken deliberate choices that I am not interested in being an arbitrator. I have made that deliberate choice. And that choice to me is because I think there is a certain temperament that requires for you to sit as an arbitrator that I may not have, maybe. So I have deliberately made a choice that I will never pick any appointment unless it's very important, necessary. And of course, I mean, it's very obvious. I mean, look at the temperament of John Ohaga, for example, as somebody who is willing to sit and listen to you, even when you're not making much sense most of the time, right? So I think we need to make deliberate choices. And let me give you examples of deliberate choices I've seen in career progression. The PCA has Bala Galma, a Kenyan, and another friend of mine called Karim Ziani, who's from Comoros, very young lawyers. Um, Karim had left Foley Hogg before that, going to the PCA, but at some point it was clear to him he wanted to transition to a more institutional role. And Bala has not, been on this side of either casework or whatever. She wanted to focus on the institution, and that's where. And they do amazing, amazing work with the PCA in Mauritius and the MIAC on the other side. And then there are those who've taken deliberate efforts to go into counsel litigation work, and I include myself in that. And that has been our focus. Now, I have to tell you some certain truths, Joseph, that may not be very comfortable, but they're just the truth. And the truth is that you need to take some time and spend that time working on, getting better for you to get. If you work for a big law firm like the one that John runs, those cases don't belong to you. They belong to John and his partners. You're not going to just come and take those cases and be the showman of those cases unless they really want you to do that. That's just the reality of how the business works. And that's the relationship that John was talking about. So you have to also start figuring out how to plug in your relationships and how to find, work that would allow you to also participate in a more meaningful way. And I think that's where many people go wrong because, you sit and wait for the opportunity. It's not coming. You have to put the work, either working with the people who are already in the system, and it works. I give you an example. I worked with Makan Meng for maybe 9 years, writing almost every pleading you've seen. And I only got my first ICJ case in 2024, 9 years after being his assistant. Took me 9 years to get to an ICJ case. And for those 9 years, I've worked on so many of those pleadings, written them over and over, hundreds of pages. But it was time. Today, the most appointed ICSID arbitrator is a French lady, and she never had a single appointment until she was 48. Right? And today, almost every state party you see always appoints her. And I think it's just a matter of time and building that time and networks. And those networks are very important. So don't be in a rush. I'm not saying sit there forever, but don't make demands when you cannot bring your weight to the table. Unfortunately, I have to be very honest with you on this because I feel sometimes younger people insist, and I think they should insist on getting to the table, but there must be some meaningful progress on it. And then there are those lucky 1%ers that you find who get into the system very early and get, but they're not the best examples. They're very few. They're very lucky, and sometimes they just had the right mentorship from the right people who really pushed their names to be there. But for the typical journey, it takes time. It takes networks to build. But also, you don't have to be one thing or the other. You don't have to be an arbitrator. You could work for institutions like what Karim and Bala have done. You could go do casework like what other people are doing, or you could become on the arbitration side and get to be an arbitrator. But start somewhere. Be a tribunal secretary. Work on some of these things, and then slowly by slowly try to carve that and find where you really fit in and where you want to do your work.
Those are some hard truths that we need to deal with. Thank you so much for that, and we do appreciate that. To our audience, we are almost getting to the plenary session. I will therefore ask you to please type your questions. I've seen a couple of, I guess I've seen some questions. I think one. Please type them there. We shall read them to the panelists. If possible, please direct them to a specific panelist if you wish them to be addressed by a specific individual. Turning or rather shifting gears to senior counsel, and there's always, or rather not always, how do we at times when doing, or rather in the field of arbitration, when individuals, in this case I mean the arbitrators, also as young practitioners, as Mr. Nyanje said, they have the rush to get into the space because they think these are lucrative enterprise. You're going to get a lot of money, and as a result, no one should be barring you off from getting into the field. How do we contrast the idea that indeed some individuals think that arbitration is a very lucrative enterprise, to the extent that some of them will treat it as a business, vis-a-vis the very intention of that process to deliver justice? How do we go about such a conundrum?
That's an interesting question. First and foremost, when you enter into this field, and Jackie spoke about opportunity, what you have is the opportunity, and you must seize that opportunity. Because I spoke previously about reputation. If you mess up your first arbitration, that's the opportunity gone, right? And it doesn't matter whether it was an ad hoc appointment or an institutional appointment. You have to remember that even institutions have their reputation to protect. And institutions, therefore, are very careful that they must appoint competent arbitrators, because when an institution makes an appointment, it is representing to the parties that they have vetted this individual and that this individual is competent. Now, if you don't make a disclosure as to a relationship with the parties, or your procedural order number one is unintelligible, or your award is set aside with the first wins that comes, that's the opportunity gone, right? So you cannot start off thinking that this is a lucrative venture. You have to first and foremost start off with thinking, I need to take the opportunity, and I need to make the most of the opportunity that I have. Any other mind frame is quicksand. And you know what happens with quicksand. So I would say to our audience, never ever start off with thinking about it as lucrative or thinking about it as a commercial venture. You have to think about it as establishing your competence, as getting off on a pathway where hopefully you can build a reputation, and eventually your competence goes without saying. So starting off from that, I would say is a false start. In any event, the whole question of it being lucrative is really dependent on what arbitrations come to you, a lot of which you have no control over. It's not like, I often think about it as, if you are a dealer for Coca-Cola, you've got the statistics. In the hot months, you can sell X number of crates. When the cold months come, demand goes down. Arbitration is not like that. You cannot forecast what will come to you. You have to sit and wait and hope. And so you cannot build it like some commercial venture. When eventually it begins to pay off, it is because you have invested. And I can tell you, the initial investment is extremely heavy. That investment outruns anything that you might have earned as an arbitrator. By the time you go off, John is in South Africa now. That's an investment, going there, attending the conference, being amongst fellow practitioners, putting yourself out, speaking, attending cocktails and side events, and so on and so forth. That is an investment. Last year, we had the C.Arb Arbitration Week. And notwithstanding where I am today, I can tell you, and Jackie will attest to it, I spent every day of that week at the conference moderating, because I was asked to moderate. I didn't have to. in many ways, I no longer have to put myself out, but it is a continuing undertaking. You must continually be available. You must continually be learning as well. There are new things that you have to learn. Third-party funding, guerrilla tactics. What are those? You know, do you even know what those are? So that when they are mentioned in conversation, you know what we're talking about. And the potential challenges to an award, all the different nuances that appear in arbitration, whether domestic or international. You must be continually out there in order to learn. When Joan mentions an arbitrator from Kenya who's very well versed, I mean, I think that I know who she is. Do you? You know, because those are the sorts of things that you need to know. And so I just go back to your question and to say, building it on the fact that it's a commercial venture is quicksand. Don't start off with that mind frame. Thank you.
Thank you so much, Senior Counsel. Indeed, this session is deeming to be one of a reality check to most of the young practitioners, because these are some of the truths that most of them do not want to face them, and I wouldn't reveal I'm one of them. Thank you so much. I do appreciate that. Maybe if we may turn to, and this will be the last question to the panelists before we turn to the Q&A from the audience. And also a reminder to the audience, please keep the question coming. We shall soon get to ask the panelists the questions, and also if you want to ask them directly, you'll be given an opportunity to unmute and ask the question. Maybe, and in closing, in this moderated discussion in the first place, Ms. Jacqueline, being in the practice and in some way having interacted with young practitioners, and as well you have given us the blueprint, if you may call it so. What do you think are the shortcomings in terms of these individuals who often, in most instances, will be the first individuals to say that there exists a grand old men club? What do you think is the main reason as to why there exists such a perception? Because in other words, perception could be deemed to inform each and everything that people do. What do you think is the miss, or rather, yes, the miss, if I may put it as such, as to what don't this individual get in terms of how it operates? Because it all comes from how everyone thinks and how everyone perceives the process. What do you think are the shortcomings of these young arbitrators? And also, for the arbitrators, or other people who have been in practice but are yet to pierce through the highest echelons in the field, what would be your thoughts on that?
Okay. Well, I want to, maybe I should share this. I'm actually trying to second guess myself whether I should share this. When I started out, I became an arbitrator in 2012. And then the talk was about the pale, what are they called? Pale, male, and stale. Pale because they were white, male for obvious reasons, and stale because they were older. And I believe this was coined by those Africans who are trying to come into this particular space. So in every age, you can always expect that there will be the younger generation looking up to those who are perceived to be at the pinnacle of practice. And there has been a general experience, if I will put it that way, that they dominate the space. So, of course, in previous times, it has been about and I don't think it has changed much, by the way. So I really don't want to dash your expectations as you start the journey. But this is what I say, and when we have engaged in this in this discussion, it is no good throwing stones, if you like, at those who have already paid the price and who have already made a name for themselves. The reality is the older men, and mostly men, have been able to engage with the journey, and they started earlier than us. So you can expect that they were able to cover more ground than us. And the rest of us have come in at different times. And so that is why I will also describe myself as being on the spectrum. But the spectrum is It's a long time. It's long term. It's a long period. But unless you appreciate, and this is the first thing I want to ask you, this like a blueprint or your to-do list. Don't look at people who have already accomplished what you aim to accomplish without asking themselves, what price did they have to pay to get there? For many people, and you included, this is going to be the reality. You're going to have to invest a significant amount of time to accomplish a level of expertise. It is actually a science. From today, just tell yourself, if you want to get into the arbitration space, you need to have at least 10,000 hours, which you have applied yourself to the study of arbitration. I did not make this up. This is from studies on expertise, on management, so that you can be able to appreciate where you're going to, how you're going to move from an early or introductory space, and then you advance, and then there's an intermittent or an interlocutory stage before you become an advanced expert. And then when you get into the expertise stage, you come and you realize you will interact with people, because in the beginning you start from the domestic, the municipal, like senior counsel described it. A point will come when you will start getting exposed to the international ecosystem. And the international ecosystem is also a different animal altogether. So learn what is domestic. Once you have accomplished that, and for C.Arb, it's pretty simple. And the good thing with C.Arb, the training that we do, is that once you accomplish this here, you'll be able to use the same post-nominals, that is FCIArb. And I want to challenge each and every one of you to, every year, just get that, invest in yourself. Become an ACIArb, become an MCIArb, become an FCIArb. It takes time. Some of us missed years, but eventually we became fellows, and eventually we became chartered arbitrators. If you acquire a tradition or a method of investing in yourself every single year, when you get to the diploma level, you'll ask, okay, so what's next? Okay, what I did was to go and get an LLM from Queen Mary University. Because I said, well, if I want to speak the language that is being spoken on the international plane, then let me go and find out what it is, the basic minimum. And please understand, when you get that degree, and I want you to get accustomed to graduating. Graduate from your LLM, graduate from your PhD, become Dr. Nyanje, yes? And read about him. Just find out how much he has had to invest to become the Dr. Nyanje that he is. Of course, you can go Senior Counsel John Ohaga's route. By the way, Senior Counsel was my classmate at Queen Mary. We sat through classes together during COVID. So when you look at those who have gone ahead of you, it's important to understand and appreciate what they have done. The older generation, and this I think will be my parting shot, they didn't appear there by magic first. Secondly, they have invested, which is what I've been talking about. Thirdly, they will not be, they would not be able to recognize you if you're not appearing on their radar. You have to make a deliberate effort for visibility, yes? And then understand, okay, it's good when we are young, we tend to be very, and by that I say this because I have daughters your age. My eldest is 22 and the other one is 19. And when we are young, and we went through the same thing, around in your mid-20s, you're still feeling there's a very collegiate approach to thinking about yourselves. But the truth of the matter is, some of you will already have a heads up or an opportunity or a door opened for you because of where you come from. It is not a sin. There's nothing wrong with having to fight harder than your colleague whom you have come up with. Rather, it is an opportunity to just ask yourself, for yourself, and say, look, and it's true, you might come from a poor family, yeah? Even many of us, and I'm sure each of us has a testimony here. We all said, look, this is where I've come from, This is where I'm starting. It may be behind other people, but that notwithstanding, I am going to do what it takes. So this is the challenge I will leave to you. If you come from a poor family, just make sure that a poor family does not come out of you. That is how we create bigger, more competent and able communities. Because when we go out there, and this has been the struggle this far, we are always told there are not enough competent Africans. I want to be able to say we have more than sufficient capacity in Africa. And by the way, for an arbitrator, the only thing you need to have, the only qualification you need to have is to demonstrate that you will be impartial and independent. That is one of the other pillars. So all you need to do is to develop that reputation that you will be impartial and independent. Many times when we are selecting the arbitrators on different levels or in different bands, the ones in the same category always have the same qualification and almost always have the same experience. So please invest in yourself. If you take nothing away from me today, please invest in yourself. You are a learned friend. It means that you are a learning organism, and you have to keep on learning today, tomorrow, and the day after.
Thank you so much once again for your insights. We do appreciate them a lot, and as well reiterating the 100-hour rule. Our panelists,
10,000 hours.
10,000, sorry about that.
10,000 hours. Then get a calendar and mark. It's scientific.
For sure. 10,000-hour rule. Thank you for reminding us of that. Panelists, I think we have come to the end of our joint discussion. I think we'll just turn to very quickly to the plenary session. We do appreciate your insights on the same. So allow me to give room to the people who have asked their questions. Some of them have typed them in the chat box. So I'll proceed to ask them, and maybe we can try and keep the answers maybe to 2 minutes at most. And for those who have any question and they would want to ask them directly, please raise your hand. Baraka should be able to activate your audio so that you can be heard or even possibly seen. So if I may begin with asking this question, and maybe particularly I'll direct it to Dr. John Nyanje, and I'm sorry for using throughout the session, Mr. Allow me to now call you Doctor. This question is from Festus Bahati, and this relates specifically to investment arbitration. And he says, from its research, and there's been an ongoing debate on whether ICSID system is effective or not. This has led to the European Union suggesting to move from ICSID system to the establishment of multilateral investment courts with permanent judges, arbitrators appointed by states. Some of the reasons cited, so allow me just go direct to the question. So my question to the panelists is whether this is the right move, or is there a better way to improve the ICDS system? Further, with regard to the emerging issue of third-party funding in arbitration, what's the influence on ICSID? So maybe you can go ahead and answer the question from Festus.
So Joseph, I think my views about ISDS are non-public. I've been writing this for quite a while. They're out there. I have published quite a number of pieces on what I think the reform in investor-state dispute settlement should be. I am more of a believer of incremental reforms, unlike my friends like your Associate Dean Harrison, who believes that the system needs to be overturned. I am not of that belief. And you know, they make very fair points on why the system doesn't work, why we need a new system. I just don't believe that's the issue. To me, I think we need some incremental reforms of changing, you know, how the system works, whether it's in appointments, especially for tribunals, because that's one of the biggest problems, but also the quantum in disputes, right? You don't want to end up with billions of dollars like we saw in PNID versus Nigeria out of somebody investing nothing from it. So I think there will be reforms. I'm not a very big fan of the multilateral court, which is very funny because it's a MIDS concept, and I used to study in MIDS when this was happening. I just don't believe it will be as fair as people think. So, because you'd end up with another ICJ. I mean, how many people are you going to keep in the court? If your big worry is diversity, how many people are going to be in the court to listen to 3,000 plus cases? I am not convinced of a multilateral court as a game changer, because I think you will end up with the same problem you have today in the ICJ on your diversity and usage, which is a big problem for the change. So for me, it's not the way to go to it. But also, secondly, I mean, I think that, you know, Africans have really put up a step towards change. You've seen the amount of appointments that are happening right now. I mean, look at the Russian saga with the Venteful, the new case that is called Saga number 2. That saga, Russia came and said, we do not want any arbitrator that comes from a country that has sanctioned Russia, right? So what does that mean? It means you've fallen out all the European countries, you've fallen out the Americans, fallen out quite a big chunk. And that is how senior advocate of Nigeria, Funke Adekoya, became president of the tribunal, right? It's because of those nitty-gritties that are coming up now in terms of your investors. So I think there are just some incremental reforms that we have to be deliberate about, and when we are deliberate about, they will work. When we are not, they will quite be, you know, problematic. In terms of third-party funding, I am really not opposed to third-party funding. I mean, especially let's talk about investment arbitration. You know, it's a very expensive venture. If you saw the study that was done by Queen Mary, you'll see that you spend about $5 million as a claimant and about $6 million on average of a respondent. Of course, I think it's much less these days. You see parties bidding for about 2.5 to 3 million US. I think the latest bid that is very controversial in Kenya is the bid by is the bid that happened recently that involves two Kenyan law firms. I think the value is 363 million Kenyan shillings for the council work. So it's between there. So most of that requires third-party funding, especially when you're a claimant. And so I genuinely believe that that is something that we need to work on, and we need to do something on, and we need to allow third-party funding into Kenya, because it's a private equity money. And I will shock you, you know, people make a big deal of third-party funding. If you go speak to third-party funding companies, just meet them around and just speak to them. 90% of cases submitted to third-party funding are never accepted. They only accept cases they are very sure they will be, because it's literally what hedge funds do with money. You take money, you go and invest in some. And number two, it's also not as lucrative as people think, you know. They have a scale, a grading scale. The last time I tried to sell an award, if you look at the grading scale on the African states, no one is above 15% value. That's the max you're getting, right? So even this idea that it interferes and it brings, you know, a lot of, I am really not convinced about it, because if you look at the numbers and the reality of it, third-party funding to me is a very important aspect of getting disputes across the line, considering how much those disputes cost. Very few companies are willing to put millions of dollars on the line to a dispute. And I think that's the importance of third-party funding.
Thank you so much. And that's food for thought for policymakers with regards to that party funding. Allow me now, I see there are a couple of questions in the chat box, and two of them from Faith, and I'll direct this to senior counsel, and I think they can be addressed as one. The question here is, should there be deliberate policies encouraging rotational or diverse appointments? And the second question is, could there be reforms, if any, would help ensure that appointments are seen as merit-based and accessible? I think they can be answered all together. Welcome.
Yeah, they certainly can be answered all together. The reality is that there are many efforts at reform. Each institution now speaks about diversity. There are specific parameters of diversity relating to color, relating to gender. So there are efforts towards reforms. However, those efforts cannot trump party autonomy. I was in a forum about 4 years ago speaking about diversity, and on the forum was an American general counsel. And his answer was a very honest answer to the question of diversity. He said, as general counsel, my first and foremost consideration is to look after myself. If the question of diversity does not answer that issue, I am not going to make an appointment just to satisfy diversity obligations. And that is the reality that, that we face as arbitrators. First and foremost, parties look after themselves. Now, if you fit within the profile of the arbitrator who the parties consider is competent and is well able to address their cases, whether as counsel or as arbitrator, then you get in. So diversity comes in the second tier. And that second tier now is when institutions are considering appointments. And those institutions might then look at, I sit on the governing board of ICA, for instance, International Council for Commercial Arbitration, and diversity is one of our primary projects at the moment. So I think what we have to do as African arbitrators also is to look after ourselves. The problem we have is African arbitrations being exported and our own parties not yet having sufficient confidence in us. So we don't really, I never really, when I'm putting myself out, I've never really thought that I'm a diversity candidate. Because when you think of yourself as a diversity candidate, then I think you're thinking of yourself as a second class, some tokenism. And that's not the mind frame that I would go into a pool with. That's not what I want to be thought of as. So I try and focus my efforts in attracting African arbitrations, first and foremost. If and when I get an arbitration that is outside of Africa, I say that just helps to elevate my status. But that's not my primary consideration. I'm not clamoring for some UK party against some Swedish party to appoint me as arbitrator. That's not the clamor that I have. I mean, recently I was fortunate to be appointed in an LCA arbitration involving European parties. But I also I realized that one of the reasons I was appointed is because of one of the parties was Russian. And so the question of sanctions comes into the equation, which means that a lot of arbitrators who are subject to the strictures that sanctions bring may not be available, and so therefore I have the benefit of appointment. But you have to be available and you have to be top of mind. So I have short shrift for the diversity argument.
Okay, thank you. Thank you for your answer. There's a question here also to you, Senior Counsel, and I don't know if, to the extent maybe your answer differs from what Ms. Jacqueline Waihenya provided as a blueprint for one becoming excellent in arbitration. And this is from Mori Chigumba, and she's asking, how does one break into international arbitration as an African? And to the extent maybe your answer will differ from what Ms. Jacqueline said, maybe you can help us, you can help in answering that question.
Again, it is by being visible. If you are going to remain in your cocoon, in your office, hoping that you can break into international arbitration. It is a pipe dream. You have to be visible, and you have to be visible on the international stage. I had the opportunity first to moderate an ICA panel back in 2016, I think when ICA was in Mauritius. That was my first opportunity to be before an international stage. And I was fortunate because a lot of work goes into moderating any ICA panel. It meant me interacting with my panelists. Some of my panelists were professors of law. It meant me guiding their discussions. It meant me reading ahead of our meetings. It meant me knowing the subject matter, the topic, and therefore being able to moderate that panel competently. And that was a result of work in terms of being visible before you can even be asked to moderate a session of that nature. It meant attending conferences, it meant investing in travel and so on and so forth. So there's no shortcut. It is hard work. It is hard work. And that's what I would say. Hard work, visibility, and competence and availability.
Thank you so much once again for those insights. I hope we can be done within the next 5 minutes, and maybe this question, I do not have an overwhelming number of questions streaming in, and maybe we might have to share them after the session so that maybe they can be adequately, because I know this topic will take forever to get at least a sense of satisfaction in terms of the discussion. And this question will be then directed to Ms. Jacqueline, and this is from Rafa, and also I ask our audience to note that not to preempt one of our webinar series on a question of underrepresentation, and women will be part of it, and the place of Africa in the same. So maybe without preempting what might possibly form the core of that debate, and Rafa asked, to Ms. Jacqueline Waihenya, you highlighted the issue of women being few in the already small pool. Would you say the issue is that qualified women arbitrators are too few, or that they are insufficiently visible within the appointment networks? Or rather, in your opinion, would you say there is any structural barriers that prevented qualified women from being appointed? And maybe this question as well could be answered together with Jimmy's Wambua question on the question whether indeed the Kenyan framework on arbitration reflects gender, socioeconomic, and generational diversity within the legal profession.
Okay. I think the shortest answer to the questions that Rafa has posed is that yes, we are a small pool, and yes, we are too few, and yes, we are insufficiently visible within appointment networks. And yes, there are structural barriers that prevent, well, first of all, qualification in arbitration, and also in appointment as well. And I think the questions or the issues that you would discuss when you are having your next discussion on the question of gender diversity, because that's really what it is all about, and also involving the youth or the younger members of the profession. We still have structural barriers against women, and mostly the first problem that we have is that almost all our laws, all our policies, all the institutional frameworks are gender neutral. Whenever you have gender neutral policies and legal frameworks, what that means is that there's no conscious attempt that is being made to include our sisters in the profession. And the challenge comes in, I think sometimes we speak about this in passing, or it seems that it is a discussion that needs to be away from the legal framework or the law or practice, but it is actually pretty integral. And to the gentlemen who are listening to us today, you have so many privileges that you may not really be aware of, because the privilege is there. It is available to you. If you take advantage of the privilege, you will be able to move on But if you don't, the opportunity will still be there, and it will be there not only today, tomorrow, but also in the future. For women, that is not always guaranteed. So I know some of the challenges that I have been expressed to me by my fellow women in arbitration. The first structural barrier that we have is that training for arbitration is expensive. Yes, it really is. It's one of the most expensive engagements that you can set your heart to or your mind to. So, and sometimes it is more perceived than real, because whenever, and by the time I told you, I made a decision to acquire, at least to learn one new thing every year. It didn't mean that I had to go for the highest top tier training or the most expensive. It just meant I needed to look for something I was interested in, that I was capable of pursuing from the beginning to the end, and one that I could tell myself, okay, this is going to cost, say, 60,000. Well, that's a big number for anybody training as a young practitioner. It's going to cost me 60,000, and it's going to be one pop. But I have 12 months. If I'm just learning one new thing, it just means that in 12 months, I'll be investing how much? 5,000. Can I set that aside for myself? The truth of the matter is yes. For those of you who are younger, you may be able to tell your parents, I want to study this. Are you able to support me? It's not a guarantee that your parents will be able to set that kind of money aside. But that is usually the training, how much the training is to be qualified in the different levels. So when, I think the last 2-3 years, we have been able to put together training specifically for university students. And then this is what we said, we'll train you online. We won't make it 60,000, we'll have it subsidized, so that each student, so long as they're a university student, they will pay 30,000 to be able to come and sit for at least the entry course. And then now, if you get a sufficient number of FCIArbs who are ready to move on to module 1, which is where you become a member, we will also extend the same rate. In the beginning, we had a really strong, response rate, and we had classes of even up to 90 people. So it does make sense. And the other thing is, if you're in a university, we did it with the University of Nairobi, we did it in person, we did it in their lecture hall. We did also with Strathmore in their lecture hall as well. This is something, and I know I've spoken to, I don't know whether she's Dr., you have to remind me her name, Dr. Lucy. We had tried to set up something for Kabarak. It didn't take off. That offer is still open. I think I am still in a position to support those of you who might be willing. Now, whenever we have this discussion, we have taught ourselves, and sorry, my sisters, we have taught ourselves as sisters that we need somebody to come and rescue us. If you want to move ahead in this space, and I think Dr. Nyanje spoke about Funke, yes? Funke has been in this space for decades. I think she was one of the early chairpersons in C.Arb Nigeria in the 90s. And she has worked consistently. She's been counsel as arbitrator. She set herself, as legal counsel in arbitrations. She has set herself up. It took her from the 1990s. We're in 2026. I think she was appointed last year. That is a really long timeline. So and she was one of the women whom I heard speak when they came with arbitral women. So she has made a consistent effort to champion women in arbitration from regional and international level. So yes, it is true, we are few. Yes, there is a structural barrier. Yes, we try to take advantage and or create a system where we can be able to bring you on board. Sometimes the response has not been as promising as it could have been. So I want, I think, to throw this in, because once you become a member, then you get into the mentorship roster. And by the way, the mentorship roster and also the roster for appointment, even with the different bands, is we call it the cab rank rule. The way a cab comes and the next person walks in to the taxi, it's not like Uber, where you say, I want to go here, and whoever is nearby. So the next person on the list is the one who is paired to the next arbitrator and the arbitration that is coming in. At this point, we are not distinguishing between women and men because you're young. Each and every one of you is young, and you need to get on to the roster. Those who prevail, because once we give you the opportunity, you either take advantage of the opportunity. If you don't, it goes to the next person. And we have women who have really distinguished themselves, but they have been ready to pay. It's just the entry level, make that investment in themselves. On the local, with the local, and you must also go for conferences. You cannot avoid conferences whatsoever. You cannot afford to be too busy. If you hear senior counsel saying that in the Nairobi Arbitration Week, he was there from start to finish. One whole week. Dr. Nyanje was there also. He was there. We were all there. We actually set aside everything else that we were doing, but we turned up. The rule, the secret to the keys to the city is showing up. I think I will end there.
Thank you so much. To our dear audience and the panelists, I think we could go all day on the topic. However, we have to come to a close, and to this end, I'll allow me not to ask any further questions to our panelists, but just to thank you for your dedication and also setting some time aside despite your busy schedule. I do understand, for example, Dr. Nyanje, you at an arbitration, and in arrangement, you had to make time and sacrifice to be here. We do appreciate that. Just in closing, I would request each and every panelist in less than a minute to give us their parting shot, and then that would mark the end of the session. I will begin with Dr. Nyanje.
So thank you very much, Joseph, for inviting us. It's always a pleasure to come and share this ideas with you and your colleagues, but also more importantly, to be on a panel with colleagues I look up to in high regard, like Senior Counsel Ohaga and Miss Jacqueline. I think the future is very bright for arbitration in the continent. I think John will tell you when they were starting, most likely there were no references to make to and to look up to, and you guys have a path that looks much better. The secret is to reach out to them and to write to them. I tell you for a fact, John replies all emails. Every time you write to him, he will reply. I can give you that guarantee. So it's good to try and reach out to the colleagues and see where you can learn, where you can get a few ideas to do everything. And on what Jacqueline was saying, there are some institutions really that really help. Especially for gender diversity, for it to be developed. One of them that we've worked very closely with is Women in ADR. So allow me to, really recognize the amount of work Women in ADR have done in Kenya. They do an amazing job to try and bring more women into the folio of arbitration. So then they have an annual moot that happens, I think, every August, every year as well. So Women in ADR is an organization I would encourage you to join, and you will therefore get a lot of help and a lot of mentorship from that. Otherwise, I also think that those networks, creating them, but also trying to figure out how to gain the knowledge in it is very important. So thank you very much, and I wish you guys all the best.
And thank you so much. I will then turn to Ms. Jacqueline, make your closing remark briefly, and then we turn to Senior Counsel.
Okay, yes, thank you so much, Joseph, for a very well-run webinar. It has been a singular pleasure and an honor and a privilege truly to also speak to you alongside Senior Counsel John Ohaga and Dr. John Nyanje. I think I will echo what Daktari said. I also look up to both of them as really singular practitioners in this particular space. And then to encourage everybody, to let them know that it is possible. When we started the journey, it seemed like it was practically impossible. In fact, we thought that nobody would ever see us, nobody would ever consider us. But, life has a way of playing out in very interesting ways. And the geopolitics is actually in our favor now. I think Senior Counsel already alluded to the fact that he was appointed in LCIA for a matter probably would not have thought would have materialized until the next decade. So take advantage, and this is what I will say. It might seem that we are lucky, and I want you to prepare for luck, but luck is not whimsical. It is when opportunity meets preparedness. So I want to challenge each and every one of you to prepare yourself so that when that opportunity comes, when it's time to seize it, it will always see those who are prepared. And I know that with the institution, Kabarak is a great place to learn new things. It's a great incubator of knowledge. And I do believe that you as learned friends are in the right place at the right time. And even though the journey looks like it is long, every journey starts with the first step. And being here in this webinar on a Thursday evening when maybe your colleagues are having fun elsewhere really does demonstrate that you're already on the right path. So I just want to encourage you to continue on the journey and take the next logical step. And you take many steps and you'll find one day I'm out of the forest. I think I just want to leave you on that very hopefully encouraging note. Thank you.
Thank you so much. And also, I know you said you have an offer for Kabarak University. We endeavor to exploit it in the future. Thank you. To Senior Counsel.
Sorry, Joseph, to cut
It's
you
okay.
short. I've remembered. She's called Lucy Thuo. We had commenced the discussion already. Yes, so
Luciana.
Luciana. Yes. Okay. Well,
I think she's no longer at Kabarak.
She's no longer at Kabarak. Oh, maybe that's why it didn't materialize. But I guess look for the next available person, and this discussion can be continued. Okay.
Okay.
Thanks.
Thank you, Senior Counsel.
Thank you very much, Joseph. Thank you for inviting me to this webinar. It's been a very instructive webinar, very interesting. Congratulations, John, on your doctorate. Very nice seeing you again. Very nice seeing you, Jackie, as always. My view has always been that the senior generation needs to be a bridge for those coming through, not a ceiling. And that's the attitude that I've always taken. I encourage mentorship. I ask people to reach out, and I try as much as possible to assist. But I'm always interested in the numbers. I was watching the number of participants. We started off at 75. I think it is 5:30 now. There are 53 left. Now, I say this because I'll tell you, for 10 years, I convened the ADR Committee of the Law Society of Kenya. Every year, I would have about 20 members in my committee discussing cutting-edge issues, discussing promoting arbitration and ADR and mediation and so on. Today, when I look at the landscape, maybe 5 or 6 are left active in the ADR space. It's the staying power. Do you have the staying power? And that's really the question that I would throw to you, because we show interest initially, but people fall off along the way. And only those truly interested will survive. And only a very few will rise to the top. So that's just the reality of it. By the time you deal with the academic rigors and get to your doctorate like John, there are hundreds of others who've stopped somewhere along the way. So it really is about staying power. Do you have the staying power? That's just it.
Thank you so much, Senior Counsel. It's been a pleasure hearing your insights and your perspective. You've indeed enriched this discussion. And to this end, we wish to thank all of you and wish the best in everything that you're doing and continue inspiring us. And we intend to emulate the steps that you leave behind. And on behalf of the Center and Kabarak Law School, allow me to thank you for being here today and wish you all the best, and also to our participants who have joined us from different jurisdictions, different law schools, and even institutions. And we look forward to seeing you to the next webinar that shall be hosted next month on the question of double agents and the ethics of neutrality. To this end, it's been an absolute pleasure being your moderator, and have a good evening and